Good morning. The Unfunded Mandates Regulatory Burdens and the Role of the Office of Information and Regulatory Affairs hearing will come to order this morning. The Oversight Committee mission statement, we begin every single one of our meetings with it. We exist to secure two fundamental principles. First, Americans have the right to know that the money Washington takes from them is well spent. Second, Americans deserve an efficient, effective government that works for them. Our duty in the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers do have the right to know what they get from their government. We will work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. This is the mission of the Oversight and Government Reform Committee. Specifically, today we are dealing with the Unfunded Mandates Reform Act of 1995, or UMRA. It was to set the Federal mandates on State, local, and tribal governments in the private sector by shedding light on expected economic impact of pending statutes and regulations. Under UMRA, each agency is to assess the effect of each type of non-Federal entity of regulatory actions it plans to take. UMRA was to help inform Congress of the potential burden of laws and regulatory actions might impose, so that those could be weighed against the potential benefits. But in the subcommittee's two prior hearings on UMRA, we heard from representatives of State and local governments and the private sector that UMRA is not identifying all of the unfunded mandates being imposed on them, and it does not always capture the full cost of those mandates that it does identify. In fact, in the past 10 years, only 4 rules have been classified as constituting unfunded mandates on State, local, and tribal governments under UMRA. Further, only 13 of 66 major rules issued in 2010 were classified as unfunded mandates. Only 1 of the 13 was identified as an intergovernmental mandate. I have 2 different slides I want to be able to show on that one. The first one deals with just the number of economically significant rules in the pipeline. You will see that has continued to grow over the years. And the second one gives us a snapshot of the major economically significant regulations in 2006 to 2010. In the purple there, you will see those are regulations subject to UMRA review, that very small little part. The red there is major regulations reviewed by OIRA, and then the green there, major regulations that have been issued as a whole. So obviously we have several that are slipping through the mix here that are not being evaluated by UMRA. While I appreciate President Obama's recognition of the burdens that the Federal Government puts on State, local, and tribal governments in his presidential memorandum on administrative flexibility, lower costs, and better results for State, local, and tribal governments, this is not a substitute for legislation to ensure the burdens placed on these entities are fully recognized and taken into account. As the charts that we just looked at show, when you look at the number of major regulations issues, major regulations in the pipeline, and those reviewed by OIRA, you see a rising trend of major regulations from the Federal Government. This is one recent indication that UMRA statute is failing to live up to its promise of reducing unfunded mandates. It is time to look at closing some of UMRA's loopholes, exemptions, and exceptions that this subcommittee has heard about from its previous 2 hearings on unfunded mandates. We need to examine whether the cost estimates under UMRA are being accurately reflected. UMRA only captures direct costs or expenditures, not the total effects on the economy as required under Executive Order 12866. UMRA thresholds are based on adjustments for inflation, but it is my understanding that is not the case for Executive Order 12866. UMRA also does not take into account the need to prepare for an unfunded mandate by a local government or private business. During the first UMRA hearing in February, the subcommittee heard testimony from the Government Accountability Office, local government representatives, and the former OIRA Administrator, Susan Dudley. Ms. Dudley, who served as the OIRA Administrator from 2007 to 2009, provided expertise and insight in the process by which the Federal Government imposes unfunded mandates on non-Federal parties. She also described widely recognized flaws that exist within the current UMRA statute and suggested multiple remedies and potential legislative solutions to address the concerns shared by many affected parties. At the subcommittee's second hearing on UMRA in March, the subcommittee heard from witnesses representing State governments and the private sector. During the hearing, the subcommittee heard from the Chief Economist of the Small Business and Entrepreneur Council regarding how unfunded mandates and regulations continually stifle private sector growth and economic expansion. Glad to see that President Obama shares the same concerns that Mr. Keating articulated to the subcommittee at our March hearing. I welcome his Executive Order 13563 and the public statements on regulations. Indeed, the President has stated that sometimes rules have gotten out of balance, placing unreasonable burdens on businesses, burdens that have stifled innovation and have had a chilling effect on growth and jobs. Further, President Obama made it crystal clear to the American people in a presidential memoranda that my administration is firmly committed to eliminating excessive and unjustified burdens on small businesses and to ensure that regulations are designed with careful consideration of their effects, including their cumulative effects on small businesses. In light of this backdrop, it seems very appropriate that we would look at reforming UMRA, not only in the context of the State, local, and tribal governments, but also with the private sector as well. Many regulations are on tap, will not be covered by UMRA in its current form, or for that matter in Executive Order 12866. For example, the U.S. Chamber of Commerce estimates the Dodd-Frank Wall Street Reform Act and Consumer Protection Act, signed into law by the President, contains 259 mandated rulemakings, 188 suggested rulemakings, 63 reports, and 59 studies. Most of these rules, those not issued by the Treasury Department, will be issued through independent regulatory agencies such as the SEC, Commodities Future Trading Commission, FDIC, Federal Reserve, and the newly created CFPB, which are exempt from the requirements of UMRA, as well as Executive Orders 12866 and 13563. All these new rulemakings create potential for the issuance of more unchecked unfunded mandates. Indeed, in light of the President's recent statements, it is curious that a recent report by George Washington University Regulatory Studies Center and the Wiedebaum Center in Washington University in St. Louis finds that the number of staff employed on regulatory matters within the Federal Government is on schedule to grow at a rate of about 10,000 new regulatory employees per year in 2011 and 12. The number of full-time regulatory employees is expected to reach an all-time high of 291,676 in 2012. The authors of the report, which include former IRA Administrator Susan Dudley, believe this data offers useful information on the composition and evolution of Federal regulation over the past 52 years and serve as a barometer of future regulatory activity. I have stated before, and will state again with this hearing, like other hearings, this is not an attack on the current administration. Many of the issues we will deal with today did not originate during this administration, and the solutions we propose will extend well beyond this administration. It is essential that we look at the bigger picture and the long-term effects of our Federal involvement in State, local, and tribal governments and private business operation. But it is also essential that each agency is evaluated on their results, not just their rhetoric. Today's hearing is designed to be another teachable moment to discover the facts to assist us in developing solutions. It is the role and responsibility of this subcommittee and Congress as a whole to ensure this administration is regulating in the best interests of the American people. I am here to make certain in this modern regulatory environment the Federal Government does not overstep its clearly defined constitutional boundaries, and well-intentioned bureaucrats don't impose their preferences on State, local, and tribal governments and private industry. It is my hope that we can also discern issues that must be addressed in a legislative solution to our unfunded mandates.